less than truthful allegations of domestic violence, which has resulted in my client being removed from the home that he's paying for.
Anderson, as counsel for plaintiff, what is the status of this matter, and do we need a evidentiary hearing before the referee?
Well, Your Honor, currently the circumstances remain the same as when we filed our verified motion for child support. The children remain in the home with my client. To my knowledge, defendant is staying with his mother in a one-bedroom apartment. So I think custody temporarily is rather a moot point. And Mr. Blumberg and I can discuss that in terms of a temporary order until and unless circumstances change. Other than that, I suppose we'll need an evidentiary hearing eventually when circumstances do change and Mr. Casper's in a position if he'd like to discuss custody. In terms of parenting time, there has been a recent change due to Ms. Casper's work schedule. Mr. Casper is having the children 2 overnights per week. So that would definitely increase his overnights that happened, I believe, last week. So that is a change.
Mr. Blumberg, from your perspective, where are we at on this matter?
Judge, we are in a situation that has been fabricated by the plaintiff in this matter. Domestic violence charges are pending against my client, which has resulted in his removal from the marital home. Moreover, plaintiff's attorney was able to obtain an ex parte order from Judge Boudet in Kalkaska County, creating a situation where he is paying for all of the expenses of the family on top of this child support order that somehow got entered. Talk about double dipping based on a set of facts that are just unbelievably fabricated. We're here today, we thought, on our objection to the child support order.
For the court, did you ever prepare a child support recommendation?
We did not. The support order that entered is the one that came from I believe, the plaintiff's attorney that was entered.
So you did not run calculations? Okay.
No.
Well, we'll definitely get that corrected. Certainly the front of the court needs to run a calculation based on the parties' financial information as well as the appropriate number of overnights. I don't see any ex parte orders in our file at the moment.
Judge Boudet signed an ex parte order requiring my clients to pay all of the marital expenses on a monthly basis. So we've objected to that. And then on top of that, Judge Boudet, apparently based on plaintiff's filings, got an order requiring him to pay child support on top of paying all of the marital expenses. That would certainly constitute double dipping.
Well, we'll prepare a support recommendation. I don't, again, for some reason, I see your objections and I see the motions, but I don't see the actual ex parte orders. But either way, I do see that there is a child support.
June 7th, Your Honor. June 7th.
Yep, I do see the support order. So we will prepare a new order, and we got to make sure that appropriate calculations were made in front of the court. We'll prepare that. Do you have income information for the parties?
I do. How many overnights though?
All right, so that's the issue. What number of overnights are we looking at currently?
Well,
This one
again,
was calculated 48.
yeah, currently based on, I'm trying to be delicate in my presentation to the court, what we believe to be less than truthful allegations of domestic violence, which has resulted in my client being removed from the home that he's paying for. Ultimately, we're seeking, at least at a minimum, a shared custody arrangement. So I guess what we would ask the court, the friend of the court, to do is to prepare one child support calculation based on equal parenting time and one based on the standard parenting time.
Your Honor, currently, I'm sorry.
Well, does the ex parte order set forth a parenting time schedule? Is that exist at the moment or not?
No.
It does not.
Okay. So Ms. Anderson, what do you think?
Well, Your Honor, again, you know, this is still an ongoing case that our prosecutor for Otsego County is certainly pursuing. So without going into the alleged fabrication, at the time of this filing, my client, before even reaching out to me, was working through defendant's mother so that he could see his children. Again, Defendant is living with his mother in a one-bedroom apartment. There are 3 children. Shared custody is not even feasible under the current.
I'm not worried about all that right now. I just want to
Okay.
know what.
As of
then the
right,
number-
yes, so
Overnights.
changes, yeah, overnights right now, he's getting 2 per week.
All right, so we'll calculate it at this time based on that, but obviously we can have a hearing, and if things change, we'll prepare a new one. So Mr. Blumberg, do you want this matter set for an evidentiary hearing at this time on the issue of custody and parenting time?
Judge, again, you're probably scheduling out till how far reasonably? Are we looking?
Well, our next, we have some 1 hours at the end of September, but our next 3 hour, we have October 14th and October 30th.
I think either of those October dates would be subsequent to the resolution of the criminal matter. So either of those dates would be
Okay.
October 30th probably would, just to be safe.
All right, Ms. Sanderson, do you see any issue with an evidentiary hearing on October 30th at 1 p.m.?
I do not, and I think that would be good, a little more time. Again, I think custody is difficult to speak about while we have this ongoing bond condition, so I think the more time, the better, so we can make informed decisions here.
All right, so we will set the issue of custody and parenting time and support for October 30th at 1 p.m. That's an in-person hearing. It looks like the oldest child is of age for an interview. The other 2, I think, are too young based on the ages that I conduct interviews. So just the oldest child would need to appear for the interview. And then we are also going to prepare a child support recommendation at this time that would be based on 2 overnights a week.
Your Honor,
Yes.
where would we send mail to the defendant? It appears both of their addresses are the same.
All right.
So we can get the correct information to them.
Judge, you can send it to my office and I'll get it to him.
All right. Okay, we'll do that.
Thank you.
All right, anything else, counsel?
Not that we are aware of.
No, we're all set, Your Honor.
All right, thank you.